Hi, I'm attorney Jacob Birenbaum of Hawley, Kaufman Kautzer, and this is a series about the ways that non-criminal citations or criminal cases can be resolved in the court system. But first, make sure to subscribe to this channel, check out other videos, and make sure to follow us on Instagram and Facebook. A common question that comes up in criminal cases is, after the sentence, what can happen with the conviction? And there are two ways that a conviction could be removed from the individual's record. The first and most common way is called expungement. And expungement is a destruction or deletion of that individual's conviction for a particular offense. The next question is, who would qualify for expungement? And the first requirement is that the individual be under the age of 25 when the offense was committed. And it's important to note that the age is not at the age of conviction, but rather the age of the offense when it actually occurred. Expungement is reserved for misdemeanor convictions and for certain felony convictions. At the time of sentencing, the court must authorize or grant expungement. There are two factors that the court takes into consideration at the time of sentencing to determine whether the individual should be granted expungement. The first is whether the individual would benefit from the expungement of their record. The second factor that the court takes into consideration is whether society would be harmed by expunging the conviction. And generally, the courts are reassured that society would not be harmed if the court puts into conditions that the individual successfully complete treatment, programming, or probation, or that the individual engaged in some sort of non-criminal conduct for a period of time. Another way that an individual could get a destruction of their criminal conviction is what's called through a pardon. The state governor can pardon certain convictions, but the process for requesting a pardon can be quite time-consuming. Pardons are reserved primarily for felonies, but it could include some misdemeanor convictions that resulted from a felony conviction as well. In order to qualify for requesting a pardon, there has to be at least 5 years from the time that any sort of sentence or supervision was completed, the person not have any other pending charges in the state or elsewhere, and that the individual is also not required to register as a sex offender as it relates to that case for which the person is seeking a pardon. If an individual thinks that they could be eligible for a pardon of their conviction, he or she must apply through the governor's advisory board, which can take between 6 and 18 months from the start of the application. There might be some hearings that are involved before the individual could actually get a decision on whether their conviction is pardoned. The Pardon Advisory Board will review the application and make a recommendation to the governor as to whether a pardon is appropriate. Generally, within a month of that final hearing, an individual will learn whether their conviction has been pardoned. I hope this video was helpful for you to understand a little bit more about the criminal process and the types of resolutions that are involved. Make sure to check out all our other helpful videos and follow us on Facebook and Instagram.